Thank you. Thanks a lot for the introduction, and nice to meet everyone. Thanks a lot for the interest. I think we were really pleased to hear that this report that we've drafted has reached also the overseas, and that you have actually mentioned it and that you find it interesting. So I'm really happy to be here and to share a little bit the report and also the project within which we've done it. Although I know the context, of course, in the EU and specifically in some of the member states will not be similar to the US, then I think, as you pointed, the individual assessment tools are used across different countries. So it's interesting also to hear, what you have or what are the issues or challenges that you see in your work. So really, thank you again for this invitation. And so let me share the screen with the presentation. Does it work? Can you see that well? Great. All right. So, as Elizabeth already said, the ICJ, the International Commission of Jurists, is a global human rights organization. So we work towards the progressive implementation and interpretation of international human rights law. And so I work in the Europe program of the ICJ. So what we try to do in our work is really to bring the international human rights standards to national implementation, or to see how that can be best reflected in national legislation and used in practice. So in this project, we really looked at the rights of the child in conflict with the law to individual assessment, also because it is newly embedded in an EU directive. So the framework, the legal framework we work with is international law, international human rights standards, but then also at the EU level, we work with the EU law and EU Charter on Human Rights and the various legislation, the directives and regulations. For instance, the directive 2016-800 that really speaks about the right to individual assessment for children has to be implemented in all national legislation of all EU member states. So also part of our work was to look at how this article is implemented in law and in practice in EU member states. But especially we looked at 2 countries, and I will speak about that in a moment. So here in the beginning, just to kind of set out the framework we work with, although that's not applicable obviously to the US, but just to show you also that there has been this new directive on procedural safeguards for children who are suspects or accused persons in criminal proceedings. And in Article 7, it speaks about the right to individual assessment. So which in that understanding is some kind of an assessment, a report that's usually drafted by a social worker or a probation officer. Different setups in different EU member states, but it really has to look at the needs of the child, and ideally, and that's I think important to look at is the purpose of the individual assessment. So the directive specifically says that it has to that it should be there to look whether there's any need to adapt the proceedings for the child so that they're more child friendly, that they basically fit the needs of the child, the specific circumstances of the child, the potential vulnerabilities of the child, so that all this should be basically, thanks to the individual assessment, reflected in the procedure, and the procedure should be adapted accordingly. And only as you can see here at the very last point of the purpose of the individual assessment, it also says that it should include also sentencing, while, and I'll speak about it in a bit, while most countries where we did some research and we looked at the legislation and especially practice, mainly the individual assessment is used for the purpose of sentencing. So it's being used by the professionals mainly to advise on the measure for the child to be suggested at the very end of the procedure. And what's also important is that it has to be done as early as possible when the child is in contact with the justice system. And it also should be carried out with a close cooperation with the child. So meaning really embedding the Convention on the Rights of the Child, right to be heard and to participate. It's very clearly also stated in the EU directive. So in our project, we looked at 2 countries, Czechia and Slovakia, because we have been already doing some previous work in this region on children's rights. Especially we brought a case, a collective complaint to the European Committee on Social Rights that concerned children below the age of criminal responsibility and their complete lack of access to procedural safeguards. And the case was actually just decided last year and published. So it was quite a good way to also look at these 2 countries in this specific context. And I mean, we knew, and that was also the idea behind the work, we knew that the individual assessment in these countries is not done in a very good way, in a rights-based approach. It's not really taking the Convention on the Rights of the Child framework into consideration as much as it should. So in the project, we were kind of researching why, but one of our ideas was that perhaps it's also because it's a post-communist country, you know, so that was like this approach to children was rather the protective or punitive one, rather than seeing the child really as a right holder. But it was interesting that when we did some initial research in other more like Western European countries like the UK, the Netherlands, Belgium, and Finland, we actually found quite a lot of problems there as well when it comes to lack of the child-friendly approach, lack of access to real participation in the process for the children. And also most of these countries, again, really just use the individual assessment to have any impact on the sentencing, if at all, so rather than on the procedure. So that was quite a surprising finding for us. And so we believe that really this rights-based approach is still not there probably across the EU. But so based on the information that we gathered throughout the project, we drafted these recommendations. It's the document that was shared with you, and that's targeted at different professionals. So it's for lawyers, judges, social workers, probation officers, and the police. But should be really, the principles at least should be transmittable to our EU countries. Just to mention, we also developed a child-friendly version or a leaflet basically for children that speaks about their rights, to really make the way to the children and make them be more informed of their rights. And we also did like a video for teenagers. So I put a link here if you ever want to watch it afterwards. You can do so. And so I just wanted to mention here, and maybe this is not necessary, but really very briefly, just the international legal framework that we're basing ourselves on. So we're based obviously in the UN Convention on the Rights of the Child and its general comments and the main principles. And that's really what also the recommendations are built around, and you can see it when you read them. And so the prerequisite really is that every child is entitled to a set of rights and that children are right holders. But then obviously realizing also that the convention has not been ratified by the US, unfortunately. I'm just also mentioning here a couple of other international legal standards or guidelines and principles that we're also using in the report and that are equally useful. Also, general human rights instruments obviously do cover children and give them the same rights as adults. So just mentioning them here in terms of an overview. So probably just to go through now the different specifics of the Czech Republic and Slovakia, because we then also built the recommendations on these specific systems. And so what is interesting is that basically the Institute of Individual Assessment appeared in legislations at national level already in the beginning of the 20th century, where also child justice systems emerged. But they were very much based on this welfare approach or protective approach, which doesn't really see the child as a right holder, but rather as an object of protection, that is kind of provided by the adults, by the institutions or the professionals. So, and here, I mean, I've pasted here like a quote from the law from the time. It really, the individual assessment is understood as like a very scientific, expert, objective examination of the child. And so the purpose there again is only to advise on sentencing. And we could say that really it has been more seen as part of evidence gathering. So, and unfortunately, we also understood that this is the understanding that it seems that most professionals still have until today. That this is basically, they're working on an expert report on the child, on their family, on their social circumstances, but a lot of times, a lot of stereotypes come into that, obviously. So for instance, just to give you a bit of a background, there is a big Roma community in both Czechia and Slovakia. And there's a lot of prejudice and a lot of stereotypes among professionals. The professionals, there's basically no Roma among the professionals in the child justice system, or, you know, there's a huge segregation in the school system. So they don't hold any of these positions. And so very often already the mention that the child is a Roma is basically gonna put them in a disadvantaged position, and it may be used against them, of course, together with other factors such as, I don't know, the child is skipping school or parents are alcoholics. It's done in a way that it's really just collecting evidence against the child to show the child is broken, so to say, the child needs a specific intervention.
Karolina, if
yes.
I might just intervene just for our Illinois audience, the Illinois Juvenile Court Act, it's similar to in legislation. There's a requirement for a report on social investigation that probation does prior to sentencing a child. And it's a very similar kind of requirement that we have in Illinois too, just to put it in context. Thank you.
Yeah, thank you. That's interesting. Yes. So, I mean, in looking at the practical problems with the implementation of this individual assessment in practice, first of all, we noticed very much the passive role of the child in the whole process. So the child is rather treated as an object rather than as a subject and a partner in the process of evaluating their needs and their specific interests, for instance. So, I mean, in many cases, the professionals who elaborate the assessment, they do speak with the child. So for them, the fact that they had a conversation with the child already mean that the child was involved or did participate. But that in our understanding is not always the case, because often, as you can see also from the testimony, the child is used also as a source of information. So they're being asked questions, but they're not really involved in the process. And what's probably even worse is that in most cases, the child will never be able to see the individual assessment nor comment on it. So this is also one of our key recommendations. And that's basically part of normal access to procedural rights. So in a procedure, one should have access to information that are gathered on them and be able to comment on them in the proceedings. Then another issue that we found, which really is a big issue as well, is the failure to identify the source of information. So for instance, there would be a social worker speaking to a teacher, the teacher telling them some kind of an information, and the social worker would write this as objective information that they themselves found out. But this same information will appear also from the report from the school, and it may appear in another report, but it may be all coming from this one source. So it may be just one person having one opinion of the child, or and so the information gets basically doubled or even multiplied by not actually providing properly the sources. So, and that really happens a lot in the Czech and Slovak context, while we actually saw, for instance, a very good practice on this in the Netherlands, where really the judges check very carefully the sources. So when they get the individual assessment, each statement, each information has to have a source, and the source of the information has to actually sign on the paper. So that the individual assessment has to be sent after it's put together to all the professionals, and they all each have to sign that they have really said this, or they really agree with this information. And so we spoke to one of the judges in the Netherlands who really is doing this very thoroughly and sending the reports back to the cited sources if they haven't signed. And she said also it happens to her that they come back and say, I've never said this, or I would never formulate this like this. So we just see this as a very good practice to make sure the information is correct. The other issue we discovered is the really uncritical institutional trust in the objectivity of information coming from official institutions. That's a little bit linked to what I said previously about the sources, but even more so, if there is an information coming from an official institution, it's given much higher trust than information coming from a child or from their family. And that's something maybe also embedded in the culture, in the system, but if there is something that the Child Protection Agency is claiming, it has much more value for the professionals in the process than what the child is saying. And that again can be very problematic, especially with Roma children that we know. There's Czech or Slovak social workers who go to the families and they see a different way of life, or they put in the report that there is a mess in the kitchen, or there was no vegetables in the fridge, but things, of course, that are maybe culturally different, but they would already have a very stereotypized or discriminatory view of the family, and often there's conflicts between the social workers and the Roma families. So this will really inevitably also have negative impact on the child. And then the other problem, and I've already spoken about it, is the objective of the assessment is not really, should not be only on the imposition of measures, but also on the procedure. So, but it's not the case. There's really no focus now to any procedural accommodations or to ensure that the child can effectively participate in the proceedings because of their minority background, language issues, vulnerabilities, or disabilities. So none of this is basically taken into consideration. So so when drafting the recommendations, we kind of could see that it's not really used as a rights-based assessment, but rather a risk-based assessment. So, and we say it's either based on the repressive or a welfare approach to children, which are different. Obviously, it's either really a punitive approach or a protective approach to children, but it's mainly the narratives that are different. But for instance, the role of the child is the same in both. The child is very passive. It's an object of punishment or care and protection. Also, not in the tools they rely on. So there are, in the end, coercive interventions against the child. There's a lot of so-called protective measures for children, even for children below the age of criminal responsibility, that involve deprivation of liberty. And yeah, the end result for the child is really still the obligation to which the child must submit. So rather for the rights-based approach, what we would also recommend is that the child really has to be seen as a right holder. the objective should be to secure the child's rights, and that also the process of realizing the rights is important, such as the result. We had actually in some of our events, we had Mikiko Otani, who is the chair of the UN Committee on the Rights of the Child, who also said that basically in the criminal justice process, the child is kind of coming in contact with the system, and it could be an opportunity for the child to see that they have a place, that they're treated with respect as a valuable member of the society, that they understand what happened. So also using that leads us to using restorative justice principles, and that it basically is an opportunity also for the child to feel like valued and be an important member of the society. So rather than just being punished and not being included. Then about the tools, so it would be good if the assessment would be really focusing on supporting the strength and resources of the child, looking at the more widely at the social systems of which the child is part. So potentially where they can find support. So basically a bit more wider mapping of how the child can continue. And the end result of the child should be rather opportunities for the children rather than obligations. So I think we went through most of it, just to also say that really there's often structural discrimination in place that basically the child is affected by from when they are born throughout, because of where they're living, if that's disadvantaged environment, if they're from a discriminated minority or disadvantaged socioeconomic background, and there's really structural violations of their human rights. Then they go to segregated schools and so on. And so this should appear in the individual assessment, but not as evidence against the child that, look, he's from this environment, so he or she just deserves this sentence, or it's clear that's why they actually offended, or that's kind of edged to the other factors why we think he's actually guilty, for instance. But rather it should be taken into account and even given give some better preferential treatment to the child. It should be taken into account in a completely different way. And there was one very good decision of the Czech Constitutional Court where the judge actually said that there was a mistake, that the Roma child wasn't given access to free legal assistance. And it went very far in explaining from which background the child came and why, even more so in their case, it's really important that they get this access to free legal assistance. But again, that was just one case so far. So I mean, in the recommendations itself, you will see they're really listed at the very end. We list the key principles that are based on the main principles of the CRC. We list the non-discrimination, child participation, child sensitivity. The assessment should be done in a timely manner. It should be multidisciplinary, and even more so, all the professionals have to have quality professional training. There should be given primacy to the best interests of the child, and in accordance with this principle, it must be ensured that any specific vulnerabilities of the child are reflected in the assessment. And then for the actual recommendations, so we suggest 3 different sets of recommendations, although they're quite similar, but more targeted first to those who compile the individual assessment, like social workers or probation officers. Second, to those who have the power to adopt decisions, like the police, the prosecutor, or the judge, and then recommendations to those that defend the child, such as the lawyers. So for the first group, basically we say the child has a right to be heard directly and also to meaningfully participate in the elaboration of the individual assessment. Children must be treated without discrimination on any grounds, and be aware of, also the professionals should be aware of discrimination patterns or their own stereotypes. There has to be procedural accommodations for specific groups of children, for instance, migrant children or children with disabilities, Roma children, children that are living in institutions. The professionals should try to have a positive relationship with the child based on respect and the child's dignity, and listen carefully and really encourage the child to participate. And then in relation to the data and information sharing, these should be processed lawfully and fairly without prejudice. Only relevant data and information for a specified and legitimate purpose can be collected. Sources in the individual assessment and other official reports must always be cited, and information should not be shared among different actors unless it's strictly necessary. And finally, the individual assessment report must be made available to the child, and they have, if they disagree, they have the right to comment, which should again then be part of the documentation that's there in the proceedings. So as I said, these are all very similar recommendations here. For those that have the power to adopt decisions, we also really emphasize the need to have access to procedural rights, especially to free legal assistance, potentially also to interpretation, if that's the case, if that's needed for the child, and also that there should be access to diversions in the proceedings. And yeah, for the lawyers, we suggest basically, again, very similar recommendations, just that the lawyer should really try to make sure that all these rights of the children are respected throughout the process. So I think, yeah, I'll end here, and thank you very much for listening, and happy to answer any questions or hear your comments as well.
So I'm going to stop the recording, Karolina, so that we can have a full discussion here.